Good morning, everyone. We are just waiting for a few more people to join the webinar before we get going today. In the meantime, you're going to get to see this very lovely start slide, the HR Trends 2025, Adapt, Evolve, Thrive. And hopefully you should be able to see me and hear everything okay. If not, please do let us know if you're having any technical issues, and we'll do our best to try and resolve those before we get going. So we're just going to talk amongst yourselves until we're ready to start, and we'll just give it another minute or two, and we'll move on. Okay. So it's now 2 minutes past. I think we've got a few more that have joined, and I'm sure the team will be letting people in to the webinar from the lobby as we get going. So let's make a start because we've got a lot to get through in a very short period of time. So as I said, welcome to everyone. It's great having you joining us here today on this webinar, which is going to be focusing on the burning platform of the day for anybody in employers' shoes, or indeed HR shoes, which is the Employment Rights Bill and the amendments, most of which are still under consultation, but we know that they are coming. So whilst we might see some changes to the details in this new legislation, we're not expecting to see any radical shifts or U-turns by the governments in relation to the implementation of these key areas of change. So if you're a business owner, an HR professional, a legal advisor, or just someone who's curious about what's coming over the hill, then this webinar is for you. So moving on then, just introducing myself. So for those who've been to one of our webinars before, my name is Gemma Todd. I am the head of HR services and projects at Kingswood Group. What does that title mean? Well, it means basically I do a lot of stuff in the back end of operational stuff, but I'm also still out there working with clients and supporting clients with their service provision and with their HR projects. I work alongside two extremely talented and professional consultants in the HR space, Laura Wright, who is joining me on the call today, and Katie Williams, who sadly isn't joining us on the call today as she has to be elsewhere. And all of us ably supported by our fantastic HR coordinator, Grace Jeremy, who is also on the call today and who is running today's presentation deck for me, so I can concentrate on the talky bits. And both Laura and Grace are going to be monitoring the comments and questions that might be submitted during the course of the presentation, and I'll say a little bit more about that in a minute. So moving on to Kingswood, a little bit about us. So why are we talking about this subject today? Well, we're a professional HR and recruitment consultancy. We have been and are committed to designing and delivering high quality HR solutions to our clients and the wider community. So regardless of size, whether that's a startup business to a long established business, we have a wide range of services and solutions that can be tailored to meet the business needs. We are not a one-size-fits-all consultancy. We make that very, very clear to everybody, because we like to work with our clients to create bespoke solutions that can be flexed and adapted to their needs over the period of time that they are working with us and we're working alongside them. We like to think of ourselves as experts in the field of HR, employee relations, employment law, and we have proven successes across multiple businesses. We take pride in knowing that our clients are well served in everything we do, whether it's sourcing and recruiting the perfect candidate for a role, or through our HR recruitment division, or whether it's crafting an HR solution to resolve a business issue in its totality. One of our core beliefs is in the sharing of knowledge and insight, and we do that through a range of mechanisms, sharing online articles and thought pieces, plus providing free to download guides and checklists, as well as our free webinar series on some of the hot topics that in HR and recruitment circles today. And if you've not done so already, please do go over and check out our website, www.kingswoodgroup.org, and have a look at our back catalogue of past articles and webinars, plus have a quick look at the range of solutions and services we offer. So just a little bit about the GoToWebinar platform itself. If we can move to the next slide, please, Grace. This is not necessarily a familiar platform for everybody, myself included, but for those who are unfamiliar with it, let me just give you a little bit of a walkthrough. So just like every other platform, it allows attendees on these webinars to participate both in writing and through spoken word. So depending on whether you're using the web version or on your phone or on a desktop, you can navigate to the relevant part of the app to ask your questions by opening the side panel and typing your questions in the box there. There is a chat and question facility. Both of those will be monitored, as I said, by Laura and Grace during the course of the presentation, which allows me just to focus on doing what I do best, which is talking a lot. But they will be telling me about any questions that are raised during the course of the presentation. So if there is something that you really want to ask whilst I'm going through the presentation, please ask it, and I will be told by one of the ladies to stop, and I'll take the question and we'll address it there and then. We also do have time at the end of today's webinar for discussing any other questions or observations, or indeed anything at all about the ERB, about the amendments, and about what you may have heard about them, and to see whether there's anything that we can shine any light on for you. All right, so let's have a look at today's agenda then. I have to start firstly with an apology, because on the original billing there were a number of topics that we were going to include on today's webinar, such as sustainability, tech in HR and recruitment. However, when I started writing this webinar, it became very clear very quickly that the size and scale of the coverage of the Employment Rights Bill and its amendments, which is going to be so impactful on businesses and employers and of course HR, it meant that simply put, I just had to decide what I had to leave out and what I was going to leave in this time around. So I do apologise if you were turning up today really desperate to know about sustainability or tech in HR. We're not going to cover that in any detail very much today. I will touch on a couple of things before we close the webinar today that might be of use to you, particularly in light of some webinars we have coming up. But today really the focus is going to be around the employment law updates, and the key takeaways from that. So today my focus is on those updates, and we know that the workplace is evolving and changing with all these new employment laws and workforce expectations and the technologies that are reshaping our industry and HR. And we're going to look at some of those key areas of interest, particularly around the Employment Rights Bill, how that's going to impact on businesses, and what you as employers, as owners, as business operators and HR professionals can do to prepare as far as possible to the changes that inevitably are going to arise from it. So I'm going to talk through a selection of the 29 key reforms that are set out in the Employment Rights Bill and just some of the amendments to those reforms. If anyone has actually read the amendments bill, there are actually 264 amendments to the 29 key reforms. So unless everybody was willing to give me at least 4 or 5 hours of their day, we probably wouldn't be able to cover all of that today. So I am just going to focus on some of the top tier items. I think it's safe to say that lots of employers may be disappointed to see that the changes announced last year around some of the significant changes to employment have not been rolled back. That includes things like the unfair dismissal protection as a day one right, or the complex provisions relating to the changes to 0 hours and low hours workers. But there is some small light in the very long dark tunnel, particularly around the day one rights, which I think has caused a lot of concern for employers, in that the government is seeking to clarify what it means by a probation period, and whether this mandatory period of time, which they're dubbing the initial period of employment, will have some sort of lighter touch dismissal process available, which would allow dismissals without a claim for unfair dismissal to be brought if the correct procedural steps were taken. But I'll talk more of that a bit later on. So these are just the tip of the iceberg, but for my money, these are the most impactful ones at this time. Unfair dismissal, 0 hours contracts, fire and rehire, and that includes fire and replace as well, statutory sick pay, family rights, sexual harassment, with light touch on that, flexible working, light touch on that, and some other proposed changes, plus make sure that we leave time for Q&A later on. It is a fairly ranging set of topics, and I will do my best to get through all of those in the time and make sure that we do have space at the end for lots of questions. So if we can move on then, please, Grace, to the overview. So many of you will have heard about already, and perhaps have even read it, the government's Make Work Pay Plan, which sought to change multiple aspects of employment law and is the core part of the government's mission to grow the economy, raising living standards across the country and creating opportunities through tackling things like low pay, poor working conditions and poor job security. In October 24, the government published its Employment Rights Bill, which contained, as I said, 29 wide-ranging proposals arising from the Make Work Pay Plan, and this bill has been described as the greatest shift in employment legislation in decades. In November 24, the House of Commons published a 53-page amendment paper to the bill, which included over 200 amendments and additions to that original bill, including, amongst other things, a cap on sick pay at 80% of salary, a tightening of the fire and rehire/replace rules, and a new right to things like bereavement leave and miscarriage. So the aim of this bill has been to, and continues to be, to strengthen employee rights from day one. This has been a key mission for this government. They want to see the offering of greater protection to those who may be subject to what they see as exploitative employment practices, for example, 0 hours contracts that balanced in favour of the employer and not the employee. The changes required further consultation and debate, and that currently is ongoing. And some of you may have been involved in that, or have been contributing to that, or have been, just like us here in Kingswood, keen observers of it. The changes proposed to the bill through the amendments are unlikely to start taking effect until 2026. However, we are seeing now some of the impacts of those coming through sooner. If things don't come through till 2026, and some of those are proposed right the way through until August 26, that does give us all time to consider the impact on our operations and our staffing, and how we can take the steps to prepare for those changes and make sure that we stay on the right side of the line. As I said, this is the biggest shake-up to employment law for more than 20 years, and anyone who's been involved in HR and employment law, as I have for more than 20 years, will know how impactful this is going to be. So there's a real need for businesses and HR departments across the country to plan ahead and be ready for the changes that are going to come. At Kingswood Group, we've already started that process of preparing policies, procedures, documents, training and familiarisation sessions for our clients. And we will continue to do that and continue to revise and amend as the changes come on stream through the bill and its amendments. Okay, so let's go to the first item then, which is the unfair dismissal, which is one of the biggest hot potatoes that was brought up as part of the ERB. So what are they proposing? Well, there's a lot, and probably too many changes within the bill to cover. But as I said, if you have got an opportunity and perhaps you're not very good at sleeping at night, then do read the ERB and the amendments and the various iterations of that have been released in recent weeks, because there is a lot of information to take in. One of the key ones, as I said, in this slide we're going to talk about is the unfair dismissal protections. And this will see the removal of the 2-year qualifying period for ordinary unfair dismissal. Now, this is arguably one of the most significant, or at least one of the most headline-grabbing changes proposed in the bill. It represents a seismic shift for businesses across the country. As you're all aware, we currently have that 2-year qualifying period for unfair dismissal. That sits under Section 108 of the Employment Rights Act 1996. And that since that right to claim unfair dismissal became law in 1971, the qualifying period has ranged everywhere between 6 months and 2 years, but has never been a day one right. Under the existing laws, employees must have worked with their employer for 2 continuous years before they are able to bring a claim for unfair dismissal, except in most cases of automatic unfair dismissal, for example, if the dismissal was related to a pregnancy or a whistleblowing. This means that the reason for dismissal must be for one of 5 potentially fair reasons. And we all know what those are, or most of us will: capability, conduct, redundancy, a statutory restriction, or some other substantial reason. And a fair process must be followed. And the employees needed to have had that 2 years in order to have had that statutory right to written reasons for their dismissal upon request. Now, the government said that this was very critical of this, and said that this left employees vulnerable to dismissal at the start of employment, and it also discouraged mobility in the job market. The bill, if the new law is passed, would repeal that 2-year qualifying period and would introduce instead a day one unfair dismissal right. And that means from the moment the employee starts to work with you, which will be likely in some cases to a statutory probation period, we'll talk about that in a minute, they would have unfair dismissal protection from the very start of their employment with no qualifying period whatsoever. Now, that comes as a bit of a shock for some employers, and indeed for some HR departments, as to how they're going to manage that. Now, this change isn't going to be implemented entirely without protections for employers who may need to dismiss employees in the early months of employment. Now, many of you will have probation periods of a fixed length, but probation periods have always been sort of flexible. They've not been regulated by statute, which allows employers to have some degree of discretion both in the duration and the terms of that probation. The government has said that in introducing this day one unfair dismissal right, they will also introduce a probationary period, a statutory or mandatory probation period, which will give employers an initial period during which there will be what they're dubbing a lighter touch process that employers will be able to follow to dismiss an employee who is not right for the job. Now, this concept of an initial period of employment, in practice, the act of a probation period, has still to be finally formalised. And the length of such a probationary period still remains the subject to consultation. However, we know, due to what's coming out from consultation, that the current government preference for this is a period of 9 months. Now, during that 9 months, does that mean a period of 6 months with a 3-month extension, 9 months in totality? Or will it be, will employers have the ability to put in a shorter initial period, probation period of, say, 3 months, with an extension up to 9 if that is what is available? Or will it have to be a total of 9 months, and every employer will have to have the same? These are things we just don't know yet. But what they are talking about is this lighter touch, less onerous process that can be used to dismiss an employee for reasons including conduct, capability, statutory restrictions, or some other substantial reason. You are going to have a reason. It cannot just be, we've changed our mind and we don't want you here anymore. So there will be changes to how HR organisations and businesses manage the exiting of people during probation period in the future. The only thing that is exceptional about the light touch is that it won't apply to anything related to redundancy dismissals, and that process will have to be followed in its entirety. So if you take people on for a specific activity and that activity ceases to be something that you can deliver during that probationary period, you simply cannot go to a probationary termination following the lighter touch, less onerous process that will exist. You will have to go through the formal redundancy process in order to not be automatically deemed as being unfair. However, again, a very small light in a very dark tunnel is that the right to statutory redundancy pay will still remain subject to an employee having acquired 2 years service. So you can still withhold any statutory redundancy pay for redundancy dismissal under 2 years. So before dismissing an employee during this initial period or statutory mandatory probation period, the employer is going to need to comply with whatever steps will ultimately be set out in the future regulations. And as I said, we're still waiting to hear that. But the specifics of that, we may not know in its exact details yet, but what we have been informed is that there's going to be at least the requirement to hold a formal meeting to discuss concerns with the employee, that the employee will have the right to be accompanied by a trades union representative or a work colleague, and that would have to take place before any decision is made to confirm dismissal. Discussions about what compensation might be applied for an unfair dismissal during this initial period, probation period, is also under question. There is an expectation that there may be some compensation for an unfair dismissal claim that is raised during that probation period, but it is expected to be perhaps lower than for somebody who is outside of that initial period. But this is all still part and subject to consultation. The change will also require employers to give all employees who are dismissed during that initial period the right to request written reasons for their dismissal without the need for 2-year service. Now, I don't know how many of you were aware of that, but currently an employee has to have 2-year service to have the right to request written reasons for their dismissal. That will be removed under the new legislative changes, and that will also become a day one right. It's expected that employees will need to have completed their initial probation period, before qualifying for the statutory right to written requests, and employers would still have to comply with that request within 14 days. But as I said, whether that goes from day one, whether that's outside of the probation period or during the probation period, is still subject to some consultation. A small window of preparation exists, because if the law doesn't get confirmed as it stands, if the changes through the Employment's Right Bill and amends don't get confirmed, we are unlikely to see these reforms to unfair dismissal coming into force until autumn 2026 at the earliest. That is the hope. That gives everybody a lot of time to prepare, because it will require a significant change in operational activity, not least of all contracts, policies and handbooks will have to change as well. So what are the areas of uncertainty? Well, I've already mentioned a number of them. The length of that initial period, it's been suggested at 9 months, but that hasn't been confirmed. The specific steps and process required to be followed during this lighter touch procedure for dismissals, we still don't know the finer details of that, and what the level of compensation for a successful claim of unfair dismissal during that initial probation period would be, and what cap, if any, would be introduced. So what does that mean for businesses, HR departments? Well, it's a significant change, and it's likely to result in more unfair dismissal claims, and that is the reality. So tribunal courts and ACAS are having to, consider the impact that will have on them as well, and whether there will be the introduction of another route to resolution other than ACAS and employment tribunals is yet to be seen. Businesses and HR departments are going to need to review their onboarding, their probationary and dismissal procedures and processes, and ensure that managers and those who have line management responsibility or supervisory responsibility for individuals, employees, are trained to address performance issues and make sure that those performance issues are addressed early on, that the default position is not the person isn't working out, we need to dismiss them, which unfortunately still does happen in some organisations. And as if that was not enough for all businesses to have to deal with, there's going to be a new further measure, which is the introduction of the Fair Work Agency. Now, I don't know if many of you have heard about this, but if you have, it does sound a bit of a sea change. So it's a new state enforcement agency for specific employment rights that will be established through the ERB. And it's going to consolidate enforcement responsibilities of the HMRC's National Minimum Wage Enforcement Team, the Gangmasters and Labour Abuse Authority, and the Employment Agency Standards Protectorate, of which I'm sure you're all hugely familiar. The work agency, the Fair Work Agency, will be granted the ability to initiate proceedings in an employment tribunal on a worker's behalf. If the worker themselves chooses not to take action, that will not be the determining factor in whether action is then taken under this new change. The Fair Work Agency can actually take those proceedings to tribunal on the worker's behalf. And it will also, as another factor, it also says that it's there to support employers who want to comply with the law. That is, yes, we need to see the details of that. CIPD is highlighted. There needs to be a broader strategy for improving labour market enforcement beyond the establishment of the FWA. That will also encompass the Health and Safety Executive and the Equality and Human Rights Commission, as well as measures for improving the efficiency of the employment tribunal system. If anybody has to deal with that, you will know that it takes a really long time to get things through the employment tribunal system as it stands, without adding in these extra complications. And there's also going to be a need for more labour market inspectors and extra resources for ACAS, so that they have their ability to advise and support businesses to comply with regulation has to be expanded fairly dramatically as well. So what are the key takeaway points for this? Well, all these areas of uncertainty still require clarification. So it's too soon for businesses to make wholesale changes to their internal employment practices. But it's clear that the proposed reforms are going to impact on how we all recruit and manage employee processes during those early stages of employment. So employers are going to need to refine their recruitment processes, and that's probably not a bad idea to consider doing that now, to make sure that they are taking the right candidate at the time, and that they select the right person for the role from the get-go. This could involve focusing on the effectiveness and suitability of pre-employment screening, interview and selection processes, and perhaps adding in extra layers of testing to make sure that whether that's psychometric, practical testing, such as use of IT, these things are all going to start to have to come into play, because the ability to take people out of a role once they have been hired is going to become significantly harder. So remember, every new hire from this point forward will gain unfair dismissal rights sooner than they did before. So it's really worth bearing all of that in mind. There are some arguments that the proposed reforms could have a negative impact on diversity and inclusion by encouraging kind of risk-averse hiring, with employers reluctant to give somebody with a different background or experience a chance. So as employers, we're all going to need to have to keep that under review to make sure that none of us face a rise in discrimination claims against us by trying to mitigate against a rise in unfair dismissal claims. So again, making sure that our recruitment and selection processes are absolutely on point and fair. Contractual probationary periods, which some people already have in place between 3 and 6 months, may need to be adjusted to align more closely with the initial proposed length of employment once that's confirmed by the government. So, for example, if the initial period is 9 months, you may want to ensure that you leave sufficient time to comply with the relevant lighter touch processes that come into force in order to dismiss employees who do not meet your company standards. So that might require some adjustment to your own probation periods and practices. And of course, managers and people supervisors are going to need training on addressing performance concerns and conduct issues early on in employment. It will be no good waiting until the end of probation, that initial period of employment, to say, well, you're not actually doing as well as we would like you to do. If there are issues, then it's a requirement to manage those proactively during that initial period to help minimize the risk of claims. Okay, assuming that I have no questions at the moment, I will then move on to the next hot potato, which is 0 hours contracts. If you could flip the slides for me, Grace, that would be great. Thank you. So I'm not sure how many people on the webinar today engage workers on 0 hours contracts, but for those who do, you'll know that there's been a lot of debate in the past on the use of these contracts generally. Many believe that they are unfavourable to low income workers, and they don't allow individuals to have any kind of guarantee on income or any benefits around job security. And this is one of the areas that the government is extremely concerned about, and why they're taking some of the measures that they are. Back in 2015, the Conservatives banned 0 hours contracts from containing exclusivity terms, meaning that the employer couldn't restrict which organisations or businesses a worker could choose to work for, as they used to be able to do before 2015. The new Labour government seeks to go further in their employment rights bill in the hope of ending this one-sided flexibility and balancing the relationship between the employer and the worker. So whilst they're not proposing an outright ban on 0 hours contract, as was initially proposed, they are proposing a set of complex rules, and much of the detail has still yet to be set out, as we know, but which creates a degree of uncertainty around some of the specifics. But we do know what the key principles are, as they're set out in the ERB and in the amendments that followed, and how they're likely to impact on employers. So what are those main changes to 0 hours? Well, I first need to mention that the ERB doesn't just talk about employees and workers on 0 hours contracts. It also incorporates agency workers, and agency workers will be included in the plans for changes to these kind of 0 hours, low hours, no hours contracts, because the government wants to ensure that agency work doesn't become a kind of a loophole in the plans to end what they see as exploitative contracts. For those who aren't familiar with what an agency worker is, it's defined as a person who works through an agency who finds them the job, and they will either have a contract for services or a contract for employment with the agency who finds them the work. The company that hires the agency worker pays the fee to the agency, and the agency pays the worker's wage. I think in old money, this used to be called temps. But for the purposes of the government changes, then it is easier to use the government language, which is agency workers. So the bill states that all workers, regardless of where they are in that continuum, will be able to access, through the changes proposed in the bill, a contract that reflects the hours they regularly work, and they will be afforded increased security to receive reasonable notice of shifts, and will receive proportionate pay when those shifts are cancelled at a last minute. Now, this is a significant change from what is currently in place, where no hours are currently contracted for, and no compensation for late cancelled shifts is given in most cases. The government stresses that their plans will still allow employers to retain flexibility on how they manage their workforce, but how does that work in reality? Well, obviously, the bill will introduce this duty on employers to offer guaranteed hours that reflects, this is the language of the bill, reflects the hours a qualifying worker regularly works over a reference period. So during that reference period, which is yet to be specified, and the suggestion is that it will be 12 weeks, how will those guaranteed hours be calculated? Well, that's still a bit unclear. The clarity on what it means to reflect the hours worked and exactly how that is worked has not yet been confirmed. But as an example, the suggestion is that if an employee doesn't work for 8 weeks, but then works 30 hours a week for 4 weeks, giving an average of 10 hours a week, the question is, will they be made an offer of 10 hours guaranteed work a week, or could the regulations say the hours need to be worked more regularly than 4 weeks in a reference period? We still don't know. We don't know the finer details, but what we do know is what the government is saying has to happen, is that the employer will be required to make guaranteed hours offer to make the qualifying worker at the end of every reference period. So this means employers who try and avoid triggering the guaranteed hours regime or minimise the number of hours they have to offer, for example, by reducing hours offered to a worker during that reference period, including terminating contracts, could face a tribunal claim. So complex in its extreme, and it goes without saying that, until we get the finer details on this all still remains a bit of a risk area. So if you are already an employer looking to start people on 0 hours contracts, I would say perhaps go with some caution right now, and I'll come on to some mitigations around that. Another part of the bill around 0 hours is that employers are going to be required to take, quote unquote, reasonable steps to ensure that workers are given specified information in relation to their rights to guaranteed hours within 2 weeks of the worker starting employment or becoming a qualifying worker. Qualifying worker, by definition, will have to satisfy certain criteria, including they are going to be working under a 0 or low hours contract during the reference period. They're going to be working a certain number of hours regularly, and if working under a low hours contract, the hours workers in that reference period needs to exceed the minimum number of hours provided for under the contract. That's a really complicated way of saying that they have to work more than those minimum hours. For agency workers, consultation is still ongoing, but the government has confirmed that it is going to table amendments to the Employment Rights Bill to include a framework for the extension of the application of each of the bill's measures, which will then include agency workers. But exactly how that's going to work in reality is going to be subject to secondary legislation, and we will keep you updated on that as and when we hear. Early consultation suggests, however, that responsibility for providing an agency worker, a temp, with reasonable notice of shifts, as we would do for any other 0 hours or low hours contract worker, will be both on the employment agency, in this case, and the end hirer. So it will no longer just be on one or other. A tribunal will be able to apportion liability based on the responsibility of each party in a given case. So if an agency worker is not given reasonable notice of shifts, that could then trigger a claim, and as it says, the liability will be prorated between the employment agency and the hiring company based on each case individually. It's also suggested that responsibility to pay short notice cancellation or curtailment payments will be on the employment agency for any agency worker, but they will be allowed to recoup that from the hiring company if they have an arrangement with a hiring company that covers this. So again, little note to self is to make sure that if you are an organisation that does use employment agencies, this may be something that you want to have a review on in terms of your terms and conditions to make sure that this is covered. And I suppose lastly on this one, the two protections that are going to continue beyond the requirement of the bill around 0 hours is the expectation to offer guaranteed hours where there is a genuine temporary work need. For example, seasonal work, that will be an exception. And the current system of extended hire periods and transfer fees under the Conduct of Employment Agencies and Employment Business Regs 2003 will also continue to apply. There's a lot to digest there around agency workers, and we are still going to have to wait for that secondary legislation to put the flesh on the bones for that. But for all workers, the government has stated that by extending protection rights beyond 0 hours and low hours and agency, they've got to put in some sort of anti-avoidance measures to stop employers deliberately putting workers onto contracts, say 1 or 2 hours a week, to try and get around the system. So the definition of how low can low be in terms of low hours is going to be a critical one for all of us. If it's too high, it could significantly restrict a business's ability to adjust their staffing levels at short notice. And it would obviously increase the administrative burden by bringing more workers into scope, which obviously a lot of employers are not going to want to do. Employers are going to have to give 0 or low hours workers reasonable notice of shifts as well. So by specifying the date, the time, the end time, and the number of hours to be worked. Again, the absence of that in accordance with the bill could result in claims being raised. And if there are any changes to that shift or the times of it, then that will have to be given, quote unquote, reasonable notice. Now, what is unreasonable notice? We're not told as yet. So, whether that is a period of time or a number of days or a particular format, verbal or written, those are things yet to be determined. The other change is that 0 hours will be entitled to compensation if their shift is cancelled, moved or curtailed at short notice. Again, what do we mean by short notice? The regulation hasn't specified that, but it's likely not to exceed 7 days. And there will be some inclusion in the regulations around the amount of compensation that would be paid in the event a shift was cancelled at short notice, and when that compensatory payment would have to be made.
Gemma, can I just ask a question?
Sure.
We've had a question from Jessica saying, is she right in thinking that the care sector may be allowed some dispensation from some of the proposed laws? So I guess, with 0 hours, things like cancelling shifts is obviously going to impact that sector quite heavily. What is it? Have you read anything on that?
I haven't heard anything. I'm aware that there are some exceptions to NICs, National Insurance Contributions, although I just did hear this morning that the petition to have hospices exempted from the hike in NICs has been rejected. So there are some businesses and industries that will have some degrees of protection. We haven't got the full detail on that yet. So whether a care sector environment would be given a dispensation for not having to pay compensation for late shift change, I haven't been given any notification on that. Obviously, if anybody does have any information on that or has been given any insight through the amendments, please do bring that forward. There is an awful lot of discussion and rumour and conjecture at the moment about what may or may not be finalised in regulation. So I think in some cases we just have to kind of hold our nerve a little bit and wait and see what comes through. But obviously, as soon as we hear anything formal, then we'll push that out to everybody, 100%.
Thank you, Gemma. I'll let you carry on. Thank you.
Okay, no problem at all. So when is it going to be automatically unfair to well, it will be considered automatically unfair to dismiss an employee if the reason or principal reason is that the employee accepted or rejected a guaranteed hours offer. So if they rejected, if they said yes, I'll do it, and then or I don't want to do it, you can't dismiss them for that. That would be rendered automatically unfair. It would also be automatically unfair if the employer tried to avoid compliance with a duty to offer guaranteed hours by sort of fudging the numbers a little bit. And also if the employer dismissed a worker because they are entitled to or believe they were entitled to a guaranteed hours offer. And it, just as a side note, it's also going to be automatically unfair to dismiss an employee as redundant for any of those above reasons. So the protections are going to get much, much harder. It makes the focus on recruiting and staffing up even more critical as we go into 2026 when the regulations come into force. Workers have the right not to be subjected to detriment. That's always been the case, but the grounds are now going to be extended for the 0 hours environment. As I said before, they are protected against any detriment if they accept or reject a guaranteed hours offers or are proposed to do so. So that they will be protected, and if they are treated and subject to detriment for that reason, they can bring a claim. They also have the right not to be subjected to detriment if they decline to work a shift on the basis that they believe the employer failed to comply with its duty to give reasonable notice of that shift, or indeed a cancellation of a shift. Again, right not to be subjected to detriment if they brought proceedings in good faith against an employer in relation to failings relating to the right to guaranteed hours, reasonable notice of shifts, payments for cancelled, moved or curtailed shifts, or if they're suffering detriment by any act or failure by the employer on the grounds that they or the employer believes that they're entitled to guaranteed hours offer. So it's a lot of words, it's complex, it's uncertain, and we're not yet sure on all the finer details. But what do we know in relation to what might happen if an employer gets it wrong and what it means for employers? Well, obviously that person can bring a claim against the employer through the tribunal system for automatic unfair dismissal or detriment, or if their employer failed to fulfil any of the duties relating to guaranteed hours contracts. So that's a significant shift. Absolutely, you know, the government wants to protect employees against what they see as I said before, exploitative contracts. But that does make the life of some employers, it's going to make the life of some employers incredibly complicated. And it's going to really impact on those businesses that engage staff on 0 or low hours contracts or temp contracts, particularly in care, hospitality and others. Employers in sectors where seasonal fluctuations of staffing are commonplace, they're going to find that particularly difficult to navigate. You know, I think getting early advice and preparation that can be done now is, as much as possible, is a good move. Now, you know, why didn't they go as far as banning 0 hours contracts? Why are they making it so complicated? Because you know, it seems like they're doing everything to actually stop employers from choosing 0 hours contracts as an option. You know, that's a question that I'm not able to answer, because you know, unfortunately the effect is going to be quite significant on employers who do choose to use them, but may now choose to use them less. The provisions may also incentivize employers to offer irregular work patterns, so workers don't work regularly over the low hours threshold, and so therefore don't qualify for that guaranteed hours offer. And while these provisions don't come into force until next year, the recommendation is that employers now should start to take some actions by identifying any workers engaged on 0 or low hours contracts or agency contracts, so that you can start to consider early doors the impact of these potential provisions well in advance of any of them coming into force. And again, once more of the detail is known, do the process again and early into 2026. It would be useful as an exercise to assess why certain people are engaged on 0 hours, a 0 hours basis, because it may well be that a fixed term contract or even permanent low hours employment may be more appropriate. So key takeaways from all of this, I hope I haven't scared you all into absolute silence, is to really, you know, do as many of the preparatory steps as you can. Identify who your workers are on low hours or 0 hours contracts, and consider whether these are really the most appropriate for the individuals concerned. Having worked in hospitality myself, what we would regularly do, even before this was a requirement, was go through our 0 hours employees, look at their pattern of work and say, well, this person works every Friday for 5 hours. We will offer them a contract that reflects that working pattern. If they are regularly working with your business, consider transferring them either to permanent, look at annualized hours contracts, or even fixed term if that works better for your organization. And if they are going to stay on a 0 hours or low hours contract, be prepared to adjust those contracts by redrafting them to incorporate the changes when they become live next year. If you already have and use agency workers, you currently won't have to make any changes, because obviously we are going to have to wait for that secondary legislation, but be alert to the fact that those changes are likely to also apply to them in some shape or form. All right. Thank you. And thank you for the question as well. So let's move to another chunky activity. And I've got a few chunky ones to get through before I can get to the quicker bit. So I will just pick up the pace a little bit, because these are quite complicated employment law changes. Fire and rehire. Now, some people would never use this, other people use this quite a lot, and it refers to the practice of changing employment terms and conditions by way of dismissal and re-engagement, typically where it hasn't been possible to obtain employee or trade union consent to a change in terms and conditions. The other one that it gets used sometimes is fire and replace, which refers to dismissing the existing employees and engaging new employees on different terms. And some of you may well remember the P&O ferries back in 2022, when they dismissed 800 employees and hired new employees on lower, less favourable terms. That's where a lot of the trigger for this activity came from. The concern obviously is that, you know, these practices apply huge amounts of pressure on employees to agree to worse terms and conditions than they had before, and then renders it, you know, somewhat unfair. So the Employment Rights Bill has recognised that and said, well, yes, we think it is unfair, and we are going to make it automatically unfair to dismiss an employee if the principal reason for dismissal is that they refused a contract variation, or to enable the employer to recruit somebody else, or indeed rehire that employee on less favourable terms, for doing substantially the same work. So this is a major change. It will say that you are automatically, it is an automatic unfair dismissal without question if you put a change of terms to an employee or group of employees and they say, no, we don't want it, and you go ahead and dismiss and rehire on new terms, having followed your own internal processes. That refusal will automatically render that process unfair, and the employees will have a right to bring a claim. The government also plans to double the maximum period for collective redundancies. Currently, that stands at 90 days for 20 or more redundancies in a single establishment. That is going to double to 180 days. Meaning that employment tribunals will be able to grant larger awards to employees who, where there are failures to meet that consultation requirement. So if you are looking to make larger numbers of people redundant and you don't comply under the new legislation with that 180 consultation period, then the award that will be given will be significantly higher. So tightening up around the rules of fire, hire, replace will make it, and I'm not exaggerating this, almost impossible for businesses to bring in wholesale changes of terms and conditions without express consent and agreement. However, dismissal under very specific terms will not be automatically unfair. I think they have granted that, and that is only where the employer can show that that variation of contract was necessary because of financial difficulties affecting its ability to carry on its business, and that the need for the variation could not reasonably have been avoided. So what does that mean? Well, in essence, the business will have to say it's on the brink of financial collapse. If it doesn't go ahead with these changes, it will cease to exist. And that would then in itself render the process fair, but that is an extremely high bar that has to be reached. So likely impact of the change, well, you may see employers using pay increases as a strategic bargaining chip, because if businesses are no longer able to force changes through to contractual terms, they may seek to hold back favourable changes which are in their control, such as salary increases or promotions, until the employees agree to the desired measures. Sounds vaguely like blackmail, but you know, I guess with organizations, they are going to need to do what they are going to need to do in order to achieve an outcome in some cases. So counterintuitively, a byproduct of these restrictions on fire and rehire could mean that employers become more reluctant to award pay increases to staff because they're going to hold that in their back pocket if they want to make changes further down the line. For businesses and HR departments, leaders, managers are going to have to think very carefully in the future before recommending fire and rehire as a solution, especially considering the financial penalties that are at stake. And the government has confirmed that it will issue further guidance on consultation processes for collective redundancies, and that change from 90 to 180 in due course. But we have to prepare for the guidance to be more detail about the application of the change rather than its removal. It will not go away, I'm afraid. So what can we take from this other than the burden it's going to place on businesses across the country? Well, it's for now, it's a matter of keeping an eye on the fire and rehire information coming out of consultation. And in the intervening period, the 2024 Code on Dismissal and Re-engagement will remain in place until further notice. And just as a cautionary note, remember that non-compliance with that code currently will end in a 25 or can end in a 25% uplift in awards to employees where employers have unreasonably failed to comply with the rules and the requirements of that 2024 Code of Practice. So key takeaways: review policies and procedures again for changing terms and conditions. Do it now. As you know, if you don't have those already documented, then perhaps get those starting in draft now, ready to ensure that those are fully aligned with both the current code of practice and also for the new code when that comes through. Training for managers when managing changes to terms and conditions is absolutely essential to avoid pitfalls of imposing changes. Even now, simply imposing a change can result in a claim being made. An organisation has to show that it's gone through due process, and simply issuing new contracts with new terms based on a decision at board or management level won't cut it. There has to be a process of consultation, even where your contracts say we reserve the right to change any terms, blah, blah, blah. There still has to be consultation and negotiation, and that has to be documented. Simply imposing a change, dismissing and rehiring, even now, if that doesn't meet the code of practice for dismissal and re-engagement, you will automatically fall foul of the law. For those with a union or employee representation, check that that you're already adhering to the correct consultation processes, and be ready for the new qualifying periods when they come in, not if they come in. All right, let's move to statutory sick pay then. I'm conscious of time. We've got a lot to get through, and I'm going to cover these next slides in as quick a time as possible because, as I said, they are quite meaty. Statutory sick pay. Statutory sick pay, as you know, at the moment we have a 3-day qualifying, three-day period or waiting period before we qualify on the fourth consecutive day for SSP, and the individual has to earn at least an average of £123 a week, the lower earnings limit, in order to qualify. The reform of SSP will see the removal of the 3-day waiting period, making SSP a day 1 of incapacity right rather than day 4, and it will see the removal entirely of the lower earnings limit band. So that means anyone earning below the lower earnings limit, 123, currently going up to 125 in April, who are not eligible will become eligible. And that is what the proposal is currently setting out. And the government has concluded that the appropriate percentage rate for SSP will be 80% of the SSP flat rate, where 80% of an employee's normal weekly earnings is less than that flat rate. So it goes back to the removal of the LEL, the lower earnings limit. So the reforms to SSP will fall to our old friends, the FWA, the Fair Work Agency, once it is set up. That enforcement body will be assigned the duty to ensure employers comply with these employment rights, and they will have the power to investigate, prosecute, and bring civil proceedings against and impose financial penalties on companies that breach these employment laws when they are passed. So key takeaways for that is be ready. Ensure your managers are informed about the changes when they come into force. Strengthen your existing policies, procedures and documents such as attendance and absence policies, contracts of employment. Make sure that you are absolutely following all your own organisation processes, return to work interviews, making sure that people are phoning in, that there are regular check-ins if people are off absent for longer periods. Training managers in the correct procedures for managing sickness absence, such as conducting return to work interviews, or indeed having informed conversations at the start of a period of incapacity, and making sure that your external providers, such as payroll, are advised of any changes when they're implemented to ensure that they are aligned to the new legislative requirements. Okay, let's move quickly to family rights. There are a load of them, and I'm not going to go through these in as much detail. You'll be absolutely delighted to know because we have only got the hour and I've just hit 12 o'clock. So those who have to leave, please do. If you're able to stay, I will cover the next sections quite quickly. Paternity leave is set to become a day 1 right, removing the 26-week service requirement, and it is proposed to be extended from 2 weeks to 6 weeks. The employee will be entitled to take paternity leave and pay following shared parental leave as well. And it would be a requirement for any employer with more than 250 employees to publish information on the internet about their policies on parental leave and pay for parental leave. Paternity bereavement leave, this is likely to come in earlier than 2026, in 2025, and the Paternity Leave Bereavement Act 24 which allows employees to take paternity leave as a day one right if the mother or a person with whom the child is placed for adoption. The intention behind this is to allow a bereaved employee to take up to 52 weeks leave in the first year immediately after the child passes. And that would be for a birth child or an adopted child. And the Act was passed under the previous government, and much of the detail relating to the rights in this paternity bereavement leave is going to, we're waiting through secondary legislation, but it will come into force later this year is the anticipation. Neonatal care leave and pay, some of you have already been alerted to this and will already have this in place. This comes into force on the 6th of April this year. So this provides parents with a day one right to take a period of neonatal leave and pay. Well, the pay subject to 26 weeks, the period of leave is a day one right if their baby needs neonatal care. And the draft regulations and the publication of the final version we are currently waiting for at the moment, but we have prepared our draft policy for this in Kingswood Group, and anybody working in an HR department should be doing the same. Bereavement leave for miscarriage is another proposal for families where, although it's not yet confirmed, an amendment to the bill will give 2 weeks bereavement leave to parents who experience a pregnancy loss before 24 weeks. As we know now, 24 weeks is the current point beyond which maternity leave can be triggered. But this will be a new right to bereavement leave. Whether that includes pay or not has yet to be determined. Parental leave, another proposal is to remove the 1 year service for parental leave to a day one. No other information on that at the moment, so we're on a watching brief. The introduction of something called kinship care, which is an arrangement where a child is raised by a friend, a relative, or an extended family member, somebody other than the parent. The legislation has not yet been fully fleshed out yet, but it's proposed that it would entitle an employee to provide kinship care for at least 52 weeks during the course of a year, obviously, and that would be whether that again is paid or unpaid is yet to be seen, but suspicion would be it would be unpaid. But again, we don't know the details of all of that yet, so please do keep watching this space. Some of these you'll already be familiar with. So dismissals during and after pregnancy. The amendment is to ban the dismissal of employees who are pregnant, on maternity leave, or during a 6-month period post return to work. And the new amendment specifies that specific notices would need to be given, and the evidence the employer would need to produce would need to be followed. And there would be some exceptions to that. We already know there are protections in place against redundancy during that extended period post return to work, but what those specific details are yet, we are waiting on the outcome. So takeaways from this is review and revise your policies and procedures where you can, tighten things up already where you can, familiarise again your managers and people leaders with the existing requirements, and then be ready to upskill them on the new, and keep your employees fully informed and engaged in the changes. It won't be enough to just make sure that your managers know. You are going to have to make sure that's communicated out widely to your employee base. Sexual harassment, you will probably know that this took effect on the 26th of October, but the proposed changes through the Employment Rights Bill and the amendments is the introduction of 2 key factors. One is the enhanced protection against third-party harassment, which was not passed through in the 26th October legislation. And then the second part is that it moves the bar higher in that employers currently have to take reasonable steps to prevent sexual harassment of employees. That is going to become employers must take all reasonable steps. And by all reasonable steps, we have as yet to see what those are specified as in the regulations, but are likely to include conducting regular risk assessments, publishing plans or policies relating to the reporting of sexual harassment, and documented effective handling of complaints with tracked monitoring and documented outcomes. There's also going to be a new provision to the new provision around third-party harassment, say from a client or a customer, that would cover all types of harassment under Section 26 of the Equality Act. So that's unwanted conduct relating to a relevant protected characteristic, unwanted conduct of a sexual nature, and unwanted conduct of a sexual nature or that is related to gender reassignment or sex. So what steps might an employer need to take to protect their employees from harassment by a third party? That may include having to change contracting with third parties. That may having to include statements on your company website. That may have to include policies that you issue when you're procuring service from a third party to say what is not acceptable and what will happen if those protections are breached. And bear in mind again, there is a 25% uplift in all compensatory awards at tribunal for any sexual harassment case where the decision is the employer did not take reasonable steps currently and in future, all reasonable steps. Key takeaways: look at your anti-sexual harassment policies and procedures now. This is law now, and you should have your policies and procedures in place, not just for having a policy that sits on a dusty shelf, but actually is brought to life through risk assessing, reporting, monitoring, training, and regular review of all of the above to make sure that any stages, any incidences, any situations where there is a risk, that you have taken the appropriate mitigating steps to prevent it. Training is really critical, and if anybody does want to know more about training, please do get in touch with Kingswood. We are doing a lot of work in this space already. I'm just going to touch briefly on flexible working, because the flexible working policy, which changed significantly last year, is only really going to see a couple of major changes. They are fairly significant. The first one being is that the request for flexible working will become the default, and acceptance will be the default. That is what the bill proposes. At the moment, obviously, it is not a default position to accept it. A company can say, no, this isn't something that we can do. But under the changes, it would be the default unless the employer has to refuse, and only if it's reasonable, and they must state the grounds for that refusal and explain why it is reasonable to refuse upon those grounds. The regulations are expected to give us more detail on what those steps are in terms of the consultation process around flexible working, and that might lead to more requests for it and more tribunal claims, because there will be a greater scrutiny of this going forward. Other proposed changes: the change to employment tribunal claims windows, that is going to go from 3 to 6 months under the ERB amendment regs, and that extension of the period in which an employee can bring claims needs to be factored in. So it would be prudent for all employers now to consider what processes they have in place for resolving individual disputes informally, as well as tracking and holding data for potential claims, because that longer claim window is going to come. Bereavement, obviously, this is going to, lots of organisations already offer bereavement leave, but this is going to introduce a new day one right, which will allow employees to take at least a week of bereavement leave. But what is uncertain at the moment is what the relationship between the bereaved and the employee is to be, and that is still to be confirmed. Of course, as employers, you can use your own discretion and apply your own relationships there, but be alert to the fact that the legislative impact, if they legislate specific relationships that aren't included in your policy, you will have to change your policy. Unfair dismissal for whistleblowing. In seeking to establish an automatic unfair dismissal for whistleblowing, it's got to be established that the protected disclosure was the reason, or the principal reason, for that dismissal. That is proposed to be changed to say that the protected disclosure need only be one of the reasons for the dismissal, thereby making it easier for an employee to establish a claim. So again, look to your whistleblowing mechanisms and policy if you've got those in your business, and if you haven't, consider introducing them to support all employees and provide absolute clarity to ensure compliance. And lastly, on this, you'll be pleased to know as we're over time, is the proposal around domestic abuse victims leave that would entitle a worker who is a victim of domestic abuse the right to take leave from work. It's expected that it would be at least 10 working days, and that their usual terms and conditions would apply, which could include terms relating to pay. Now, we still don't know the details of all of this yet, but we do know that, like with every other type of legislation, the employee would have the right not to be subjected to detriment if they were to be taking leave for the grounds of domestic abuse, or if they are a victim of domestic abuse and affected directly by that, and it would give them an additional layer of protection. So employers will have a duty to take reasonable steps, and also the legislation suggests that employers have a duty to take all reasonable steps, remember the all from sexual harassment, to prevent their workers from experiencing domestic abuse during the course of their employment. The focus here is on workers, not just restricted to employees, so therefore that protection would extend to a wider category of workers, encompassing contract workers as well. So that is one to watch with a very close eye as well. If you want to know more, please do go to our website and download our employment rights checklist. This is a live document. We are updating this on a regular basis, and you can access information which we update as and when we get it. You'll also be able to view past webinars and access articles and news items too. Now, I want to just touch on, before I come to questions, we've got 2 webinars coming up. The first is the recruiting and retaining the right talent. Hopefully Grace will have that on her screen, which is one for those who may have missed out on the section for this webinar around recruitment. And then another one coming up in May, which is stop harassment before it starts. This is obviously specifically around sexual harassment and other forms of harassment too. So if this is a subject of interest to you, please do go over to the website, sign up, it's free, and you're more than welcome to join us. Some other useful tools that you can access through our website. We have on the screen for you, obviously the bill, a sexual harassment risk assessment form, and also an HR benchmarking assessment, all things that you can sign up to and do for free and get some really useful information just by popping along to the website and accessing those. Additional services that we offer, just as a final, a whole series of them around things that we can do. So if anything that we've talked about here today sort of triggers a thought in your mind that you might need some support with this, we do obviously support loads of businesses around HR project management. We offer training, we offer access to an EAP, we offer well-being and you know, a multitude of services and support mechanisms for employers and employees alike. We also offer e-learning. So again, we can do those as individual courses, but most popular with our employers are e-learning bundles. If there was a bundle that you particularly wanted that you didn't see appear in the bundles that we've already created, then we can create a bespoke bundle just for your business. Really useful for care, hospitality, but all sectors as well, where we can create cost-effective solutions for your business. And that is me out. I am so sorry that it's taken me over our time. It is an awful lot to get in the time frame. So I will then stop talking now and just sit back and say, if there are any questions, please feel free to ask. You can take yourself off mute.
Doesn't look like we've got any questions at the moment, Gemma. I think that's okay. It. I think people are having to
dive off. Yeah. Okay. All right. Well, thank you, everybody. I really appreciate it. Anything, the webinar is going to be uploaded to our website. So anything you want to go back over and listen to again today, please do feel free. Also, do look at the back catalogue. There's a lot of interesting stuff in there. And if you can join us on some future events, please do so.
just one from Ricardo, just a thank you. Thank you for the presentation, Gemma.
You're very welcome, Ricardo. Thank you for joining us, and thank you for being patient and hanging on until 12:15.
Okay.